Welcome back to RR Legal Talks. We have two channels, RR Corporates and RR Legal Talks. Now we are going to discuss on transfer and transmission of securities, transfer of shares and transmission of shares, Section 56 of Companies Act 2013. So what are the legal proceedings for share transfer and what are the time limits for delivering share certificates? Applicability to demat of shares and special provisions for government and IFSC companies. And we are also going to discuss on penalties for non-compliance. So transfer of securities means the voluntary transfer of ownership between the two persons, transfer or transferee. So as per section 56 of section 1, a company can only register a share transfer if proper instrument of transfer, that is SH4, form SH4 is the instrument of share transfer that is duly submitted to the company. It is duly stamped, signed and dated. So the transferor or transferee, any one of them, delivers it within 60 days of execution. So once the parties are signed on SH4, it has to be delivered within 60 days to the board of directors of the company, along with the original share certificates or allotment letter. If shares are in demat, so the transfer is done via depositories and does not require SH4. So this is exception for government companies. Transfer of bonds by mere intimation from the transferee is allowed. So no SH4 needed. Transmission. What is transmission? In case of death of shareholder, insolvency or succession. So transmission is transfer by operation of law. As per section 56, subsection 2, the company can register the transmission on receipt of intimation. No SH4 needed for transmission. Section 56, subsection 5, validates transfer made by a legal representative even if not registered holder. Section 56, subsection 5. When the transferor alone applies to register a transfer of partly paid up shares. Now we are discussing on transfer of partly paid up shares. So the company must give notice to the transferee because it is a partly paid up share. So if transferee raises no objection within 2 weeks, the transfer can be registered. So what are the time limits? Under section 56, subsection 4, time limits for delivering of share certificates in case of debenture certificates. So the time limits 2 months from incorporation for issuing of shares for subscribers to memorandum of association. This is at the time of incorporation, and post incorporation, the company will issue shares to the subscribers to MOU. And 2 months from allotment for fresh shares. Any fresh allotment? 2 months. 2 months from the date of allotment. So 1 month from receipt of SH4 or transmission intimation. And for debentures, yes, 6 months from allotment. If shares are in demat form, then company must inform the depositories. So that has to be immediately intimated to the depositories. If IFSC companies, there is an exception, they get 60 days instead of 1 or 2 months as per 2007 notification. So what about the penalty for default? As per section 56 subsection 6, if a company fails to comply with subsection 1 to 5, we just discussed, the company and every officer, the company and every officer in default is liable to penalty of 50,000 rupees each. Company is liable and every officer in default also liable. Penalty is 50,000 rupees each. If there is any fraud, so depository fraud provision is there under section 56 subsection 7. If depository or depository participant transfers shares fraudulently, then they punishable under section 447, which deals with fraud and imprisonment. This is what about section 56 of Companies Act 2013 regarding shares, share transfer, transmission of shares, and the time limits, and the penalties and exceptions. My suggestion is always ensure that your company maintains robust share transfer procedures in line with the law. Like, share, and subscribe for more such insightful videos. We have 2 channels. Please do subscribe for RR Corporates and RR Legal Talks. Thank you.